Welcome to this Legal Study Skills podcast, looking today at reading and using cases. So this is what I'm going to cover. Firstly, why should I read a case? As a law student, what's in it for you? And basically these are the main arguments for not just relying on your textbook and reading cases. So I make the argument there in the first bit of the podcast. And then look briefly at how a typical English law case is structured, and then go on to examine how you should read a case and where would you find cases if you're undertaking a research exercise such as an essay. So firstly, why should you read a case? Why should you read cases? My main reason is to help you develop critical analysis, and in this sense in four main ways. It's possible to do an entire module just from cases and journal articles. A rather extreme example of that was my master's in law, where they would give us every week a file of cases that we had to read for our particular sessions in that week. And that's an extreme version because they would literally give us every single case that had to be discussed in whatever length, and we had to examine it. And the only real way we could do that was actually through dividing out the cases between a study group and going through them. A more rational way was how it was done in my undergraduate days, where we all used textbooks, but we supplemented it with reading as many cases as we could. And there was a culture there where that was encouraged. And it was really quite useful when you had a module that you were really interested in or really struggling with, to delve into the cases, because it tended either for the subjects that you really liked, it was a way of getting more in depth into the subjects and really understanding it. For the ones that you were struggling with, the temptation is always to go more basic, to get a more basic textbook, to kind of almost disengage and hope that there's a sort of an easier pathway to understanding, whereas usually it's the opposite is the best solution, which is to get more in depth. And one way you can do that is by reading a case. So you're reading something on a particular point in a lot of depth, and that is likely to help your understanding of things. So it is possible to do, pretty much your whole degree in law in the UK just from cases and journal articles. If you think about it, all a textbook is doing, and I say all as if it's something small, but what they are essentially doing is getting the law and explaining it to you. They've read the law and they are explaining it to you. So I suppose the value of a textbook on a subject that's primarily case law based, such as contract, tort, delict, equity and trusts and land, these are primarily case law based subjects, and they're supplemented by statutes, but they're not statute based, statute heavy subjects. Is to read those cases as a way of getting to know what the law is. And that's essentially what the person who's written the textbook has done. That now, you shouldn't confuse the fact that someone very eminent has done that in a textbook with the fact that you can also read the cases. There's nothing to stop you from doing that. So a textbook is only an explanation of the law, and if, for example, the law was in a statute, an act of parliament, or secondary legislation, or a mixture of the two, you would still have to read that as well in order to understand what the law actually was. So it is completely possible to structure a module in such a way that all you're doing is reading cases and journal articles and perhaps just using the textbook to get the opinion and perspective of the writer on how he or she interprets that case. So that's a very rare thing these days for an entire module to be done that way, but there's nothing to stop anyone who wants to do it that way from focusing on that. All you have to do is take your cue from what the person teaching you the module has said are the key cases, because we as academics have a choice to make as to what cases and what principles we're going to teach. Each of our subjects is potentially a huge area of law, and we're only providing you at undergraduate level with an introduction to that. Obviously, it gets more in-depth and more specialized if you've already done a related module. So that's the first point, which I've laboured quite a lot because I think people often ignore it. All the textbook is doing is telling you what the law is and giving you their interpretation of it. You can certainly get to know what the law is from reading the cases themselves. So reading the cases gives you a whole number of things. Firstly, the judge or the judges look at an issue from at least two angles. And that's by definition because they're always trying to solve a case between two parties or two sets of parties. And they may look at the issue from two angles and prefer one, or they may look at the case from those two angles and actually say, well, neither is actually right in terms of the reasoning, and here's another way, a better way that they argue, that they explain is the right way to look at the case, to solve the case. So by exposing yourself to what the judges say and how they analyze things, you're getting into the habit of seeing things from two perspectives, from at least two perspectives. And that's really important for critical analysis. If you want to know more about critical analysis, there is a separate podcast that talks about that. But in a nutshell, critical analysis is the ability to answer a question by looking at different ideas that people have put forward, whether these people are judges, academics, law commission, or any other stakeholder who's had a say in what the law is or should be. So it's about looking at these arguments, not accepting them at face value, assessing their positives and their negatives. Now, judges are systematically doing that. You could say that is their job, to appraise arguments. So they will summarize, they will explain what each side's argument is. They will tell you what the advantage or disadvantage of either side's position is, and they will then decide what the best reasoning is and the best conclusion. And it's important to note, they're not just looking at the end result. They're not just saying this person wins and this person loses. They are explaining why this person wins and this person loses. The other reason to read a case would be to help assess a claim that's made in a textbook or an article about the case. I remember one of my professors at university, who was actually quite junior at the time, and they were sitting on a PhD assessment. So they were assessing the person who'd done the PhD. And they'd picked up that this PhD student had argued that Professor X had said that this is what a particular case stood for. And he asked the PhD student, my tutor at the time, have you read that case? Because my understanding is that's not what the case says. So which bit of the case are you referring to? And they dismissed, the PhD student was quite arrogant about it. They dismissed it. They said, oh yes, but it's Professor X who's interpreted that case that way, so I don't need to read the case. Turns out Professor X, being human, had made a mistake, and that is not what the case said. So I'm not saying that you would read a case just to make sure that the textbook got the law right, it's more that you will read it in order to appraise if what the textbook is saying about the implications and meaning of the case is right or wrong. So they could have argued that the reasoning on this point wasn't very convincing, and they may not have told you what the reasoning was. They may have summarized it, for example. So going back to the case and reading the full reasoning allows you then to see, A, understand the point that the textbook writer was making, and B, decide for yourself if he or she is right or wrong. So again, it's about developing this ability to critique a position and to see things from different perspectives. The other thing is, it gives you reading cases gives you a really deep understanding of the subtleties of the law. And this is really in part because the judges can be great teachers. Some judgments, for sure, are very bland and dry, but actually the majority of them are extremely well written. And that's not surprising because the judges are some of the best lawyers in the country. Some would argue, by definition, they have to be the best lawyers in the country. And the system here in the UK is that we choose judges not necessarily as a profession, but towards the end of their career as either lawyers or academics. So these are people who are extremely good at explaining things. Most of them have either been academics or have been practicing lawyers. And the thing practicing lawyers and academics have in common is that they should be very good at explaining things to people. And that's what the judges are doing. They're trying to convince you, even though they have the power to decide the case, they're trying to convince you and the rest of their colleagues that their position is right. So it's almost like a sales pitch of why their understanding of the law is good. So they tend to be fantastic writers, and they tend to be very convincing in terms of how they explain the law. So you can actually learn a lot from them. So that's kind of the overall main reason to read the case, which is to help you develop your abilities in terms of critical analysis. And you can do that comes from having exposed yourself to a lot of cases where judges are constantly trying to appraise different arguments. It'll help you see how they do it, and you can definitely learn a lot from that. It'll help you assess what a textbook says, not so much about the law, although that could be the bit that you are uncertain about. It's more about what the textbook or an article says are the implications or weaknesses or strengths of a particular case. It helps your legal knowledge because the judges are great at explaining things. And don't forget, there are people, even though I went to university many years ago, there are people who still just primarily read cases, and they tend to do extremely well because they have an incredibly strong affinity with the law and with the facts, and they supplement that by reading journal articles. So it's entirely possible, providing that your lecturer has identified the key cases that you need to know about, to just read the cases. So that's one big point. The other point at the bottom of the slide there is you may read a case just to clarify an aspect of it, whether that's the facts, the ratio, or the reasoning. Again, textbooks may do a really good job 95% of the time, but again, it's really difficult to write, a textbook of 500 pages where every single explanation of every case is to everyone's liking. There's no perfect textbook. So it might be that on a particular chapter you've read, most of the cases have been really well explained, but there might be one or two that seem really important where either the facts are described in an unclear way, or the ratio of the case is described in an unclear way, or the reasoning that led to that decision being unclear. In which case, what you will do is jump into that case in order then to either look at the facts, the ratio, or the reasoning. Now, I've underlined reasoning because that tends to be the bit that's unclear. Textbooks tend to do a really good job usually of telling us what the law is and the facts of a relevant case, but it's usually that you need more to understand the reasoning in order to make sense of the ratio of the case. And that's a good reason to jump into a case, to supplement what you've read in a textbook. Another reason you should read a case is to develop affinity with the facts. The more cases you read within a topic, the more you will see the facts in depth. And that's really invaluable for problem questions. Because in a problem question, the academic setting it will try and make sure it's kind of neutral, that it doesn't replicate 100% obviously a particular case. But they may have in mind particular cases when they're developing the facts, and they give their own spin on them. So therefore, having a very good grasp of the facts, which you can only really get for some of the more complex cases by actually reading those cases, will really help you with problem questions, because it means you have a point of comparison, several points of comparison, to compare the facts in the problem question with the facts in the cases you're using as authorities. Now, for those of you who are at an honours stage, so you've passed the years where your degree results, your exam results don't count towards your degree, and you're at the honours stage, the problem questions get a bit more complex in that they will throw in areas of controversy. So where the legal issue is perhaps unclear, and it may be unclear because the facts of different cases are subtly different. So knowing the facts of those cases in depth is really useful to answering those type of advanced problem questions. Now, I'd also say, and this links into what I said before about the judges being great teachers, they're also great teachers because they have such a marvelous command of language. And I would almost almost say that you should have a little pad with you while you're reading these judgments and underline expressions that you think are going to be really useful when you come to write your essays and your problem questions. And I certainly remember doing that in my final year of university when someone mentioned that I should do that. And it really helped me measurably in terms of the range of my vocabulary, the way I structure my sentences, the way I express myself. These people are some of the best people at using language. So you should definitely learn from them. Now here's a bit of a googly, if you like. I was in legal practice for a number of years, and I saw that in England, at least, a lot of people who go on to do law have not got a law degree. They do something called the GDL, which is sometimes known as a conversion course. So they do the obligatory, or what was then the obligatory modules. And they do it in a year, and most law schools on the LLB will take about 2 years to get through them. And this is just my personal view, but what I noticed, not just with people in my firm, but friends I knew from and people I dealt with in other firms, and students who did the GDL, is that they tend to be very afraid of black letter law. So of things like areas of law that are based on case law or statute, and they prefer to be in more transactional subjects, specialisms. So they prefer areas of law where your key skill is documenting a deal that your client's doing, rather than kind of advising them on the law as you would as a dispute resolution lawyer or a competition lawyer or a tax lawyer, and to a large extent an employment and pensions lawyers and others. But then you've got other kind of more transactional subjects, and they tend to, those who've done the GDL and haven't had to read a lot of cases, because the GDL is frankly a sort of very, very basic version of the subjects you do at university. They've never really been forced to read cases or had to go in that amount of depth. As a result, and not as any criticism, they tend to be very skeptical about going into those kind of areas that have a lot of case law or have a lot of legislation. So my advice to you is to get over that fear. If you're thinking of being a lawyer, you want to give yourself the widest possible choice of the different practice areas. And if already at university you're afraid of reading cases, it's going to close down a whole load of areas of practice for you. And there's nothing wrong with being a transactional lawyer. I think it's actually great fun. But you want to have a choice there. So give yourself that opportunity by actually getting comfortable with reading cases. And like everything, if that's new to you, start off slow, as with everything, and increase as you go along. So don't think you're going to read 7 cases a week. That's not going to happen. But start off slow, and for example, in my module, I usually get people to read at least one case a week on average, and sometimes more. So it's important to start, because you will get much, much better at it very, very quickly. And by the end of your 3 or 4 years, you'll be much more confident with that kind of thing, and it'll benefit your grades and it'll benefit your understanding. Here's the thing. In legal practice, not reading the primary law, the statute, the case law, or the treaty, whatever it might be, and then giving advice without having read it. So in other words, you just relied on textbooks or some kind of resource like that, like a practice note or something, and you actually haven't gone and read the source material. If you get the law wrong or apply it wrongly to your client, that's potential professional negligence. Because there might be something about the facts in a particular case that are actually very similar to your client, and you missed it by just relying on a kind of a more basic guide, a secondary source. So it's really important that you understand that, and that's why people shy away from those kinds of areas of law where they're not confident about reading cases, because they think, rightly, that if I'm not confident about reading cases, I don't want to be in an area that relies on reading cases and reading complicated legislation and that kind of thing. So you have to kind of understand that it has a kind of really important potential negligence issue if you're not, as a lawyer, reading those areas, reading those cases and other primary law. So this kind of brings me on to what cases should I read. Now I've made the points about why you should read cases. The question then becomes, well, what cases? And there's no way around this. This all really depends on what your person taking your module recommends. And what he or she tells you to do, I think, is usually good advice, and you should follow it. There's obviously the point to be made that if you're doing an assignment and the assignment is based primarily or in an important way on a particular case, well, obviously that case needs to be read. It may be the case that the particular case you're asked to look at is a long line of cases ending with that case, in which case you've got a choice. You can obviously start by reading that case and see what the judges say about the previous case law, and that's usually quite an efficient way of doing it. And then you can identify within the previous case law, well, which cases seem to be really important for that judgment. I'll go away and read those as well. Or you could do the opposite, and from your textbook reading that there were a series of cases culminating in the case that you're looking at, and you could start reading from the beginning and read the 3 or 4 cases or the 5 cases, whatever it may be, that lead up to the case you're meant to be analysing. There's no right or wrong. There's pros and cons of either. The advantage of starting with the latest case, which is the one you're meant to be writing your essay on, is that you get the lie of the land quite well, and you see how the judges have interpreted the previous cases, and then you decide which previous cases to read. However, the downside of that approach is that your idea of those cases is being coloured by what the judges have said in the latest case. Whereas the advantage of reading them chronologically in order is that you get to develop your own thinking about each particular case, and you see how the cases have evolved, and then you can better assess what the judges did in the last case, the one you're meant to be writing about. So it's pretty much horses for courses. You can't go wrong either way, because there are advantages and disadvantages of either, and of course the person taking the module will give you his or her view. So we've looked at why you should read cases and how do you figure out which cases to read. And before going on to tell you sort of the nuts and bolts of how to read a case, and a lot of it is really down to you reading a lot and practicing, let me say something about the structure of an English law case, because that has a bearing on which bits of the case you read. So most cases are reported in law reports, and they're also reported these days from the courts themselves. So the High Court or the Court of Session, the Court of Appeal and the Supreme Court will publish their own judgments, and it'll simply be the judgment, and that's it. Law reports will kind of try and add some value, and what they'll do is they'll set out the facts. They'll tell you what was held, the ratio, and then they'll summarize the arguments of counsel. I tend to ignore all that, because the facts will be given to me by the judges. I'd like to work out for myself what's been held, and I may have already read about that in a textbook. And again, the summary of the arguments isn't usually always in full sentences or particularly coherent. And again, the judges will really engage with that, and they'll give you a very good understanding of the different arguments that were made by the parties. So I tend to just focus on the judgment. And you can use the law report, facts held, and summary of arguments as as kind of a sanity check. But they tend to be as dense as the facts and summary of the ratio in a textbook, so you don't really get much from looking at that. In terms of how judgments are structured with, in the old days, older cases tend to have just page numbers and the letters A, B, C, D, E, F, G, H down the side. So if you wanted to pick a particular bit, they obviously hadn't, twigged that you could use numbered paragraphs. You'd have to say, quote, page 923, C to D, if it's halfway between C and D. Now most judgments have numbered paragraphs and have done for a number of years, and everyone tends to use headings and subheadings. So actually, when you're looking at a case and trying to figure out how much of it, oh, this looks massive, it's 60 pages, it may be that the first 10 or 15 are just the facts, the held bit, summary of arguments, and also sometimes they list all the cases that were used in arguments and all the cases that have been used in the judgment, almost like as a service to the reader. But you can happily ignore all that and just look at and just concentrate on the judgment. So that's how they tend to be structured. So how should you read it? I think you should be smart about how you do it. I think you should first read about the case. So a good textbook, a detailed textbook, will give you the facts and what the case is about and what it decided. You can also look at a case note, especially if they're quite short, if they're sort of 5 pages or 3 to 5 pages. They can be really useful because someone's already done the hard work of figuring out the facts for you. And it's really knowing the facts that will help you read the judgment, and having the facts in front of you, perhaps in a diagrammatic form, whatever form helps you to understand and to follow the judgment. I tend to focus on the facts from the textbook. As I said, I tend to ignore the bits in the law report version of cases that tell me what the facts are. They tend to be too dense, and the held bit is their opinion. It's not part of the judgment, so I want to assess that for myself. And I don't read the summary of the arguments bit at the front either, as I've just said. Now, cases don't always come in very discrete topics. So you might be doing a topic on penalty clauses, but the case deals with penalty clauses and something else. Now, if you're just reading it to understand the law on penalty clauses, well, that makes your job slightly easier because you only need to focus on the bits that relate to penalty clauses. The other thing is, why are you reading this? Are you reading it because there's either the facts, the ratio, the reasoning that's unclear from the textbook, in which case you're just going in to get a full idea of the facts. You don't need to read the whole thing. I would, recommend that key cases you read the whole thing. But if you're just going in because, as we said, textbooks are not infallible, so they can get things unclear. So you're going in just to check what the law is, check the reasoning, check the facts. Whatever you're using it for, I think it's important to look through the judgment first and make a note of the headings and subheadings, perhaps in a Word document, so you can then supplement your notes within that quite easily. And then decide whose judgments you're going to read. It may be, again, if you're just wanting to know the law, well, you only need to read the majority decisions. So if it was, say, 2-1 in the Supreme Court, 2-1 in the Court of Appeal, and you're reading it just to know what the law is, well, then you'd read the 2 majority decisions. If, however, you're writing an essay on an issue and you're trying to critically analyze that issue, so for example, you're trying to critically analyze what the law is, well, then I definitely would read not just the majority view, but any dissenting opinions as well, because they obviously are critiquing the law. They're saying the majority view is wrong, and here's why. So if you're just reading it to find out what the law is, by all means, just read the majority judgment. If you're doing it to analyze how good the law is, which is increasingly the case as you get on with your degree, then you need to read the whole thing. So let's say you're reading the case now, you've decided this is the case I need to read, and I'm going to read all the judgments, the majority judgments, whichever. How do I go about taking notes here? And I think the advice here is the same as taking notes in any other context. Taking notes from a textbook or from a journal article. You're trying to get certain things out of it. If you're just trying to analyze the whole case, it's really, really particularly important to be active, to read actively. And that means not passively. You're not just sitting there just highlighting everything because everything turns out to be important. You're not really learning as you're doing that. First thing I'd do is I'd get the facts really clear and written in front of you so that you have that as you're reading the case. Quite often the judges will refer to the first defendant, the second defendant, third defendant, and unless you know who they are, it might get really confusing. So it really pays to spend a bit of time at the beginning trying to get your head around the facts. And you may have already got some of the facts there from reading a textbook or a case note, but then the judgment may go into more detail and it may identify who each person is in more detail than the textbook did. And it's important to get the detail down of the facts because they're going to refer to them as the judgment goes on. I tend to use the margins. I tend to print out the case and use the margins for notes. If you're not printing it out, you can just write the notes as you go along. And I tend to put on the left margin what the main point is that the judge is making here. And then on the right margin, any sub-points within that paragraph. I highlight only the absolutely key points. And then, after I've read the judgment, I'll take down the notes that I've put in the margins and that I've highlighted. And I'll aim to get basically just a roadmap of the case. So 3 to 5 pages for a 30-page judgment. And as I'm doing that, I'm noting down the paragraphs or the page numbers where things occur. So, for example, I could simply put analyzes previous case, Cantor and Cantor, rejects its relevance, paragraphs 35 to 38. Okay, so that just gives me a roadmap for the case. You can then read, once you've read the case once quickly, you can go back and then read it more slowly with the notes in front of you, and you can supplement them if you think you need to, but I would stick to something like 3 to 5 pages for 30 pages of text. So you're taking notes. What are you looking out for as you're reading the judgment? Well, you're looking for how they use precedent. So what cases are they relying on? How are they interpreting those cases? Are they following the cases you'd expect? I mean, there's an area of law, for example, in the law of trusts that relates to cohabitation and what happens when people who cohabit, who aren't married, break up, and how do they split the assets that they have been living in, the house, car, other things, savings. How do they split that between them if they're not married? And in that area, it seems that a lot of the courts have ignored some of the more high-level judgments, like the House of Lords judgment in Lloyds Bank and Rossett. This might not mean very much to you if you haven't studied trust, but the point is, sometimes the courts don't actually follow the binding force of precedent in the way that you'd expect them to. And there becomes like a conspiracy where not really a conspiracy, but it looks like a conspiracy where everyone's just not mentioning a particular judgment because they don't like it, essentially. And it can happen. So you're looking at that, which doesn't, the kind of use of precedent doesn't go wrong too often, but you're also looking at what particular cases led the judge to the conclusion that he or she took, and how big a step did they make in relation to the previous judgments. And if they departed from previous judgments, and they were entitled to, well, what policy reasons did they give? What was their rationale for doing that? And sometimes this is express, and the best judgments will do that. They'll expressly tell you what they think and why they're departing from previous case law. But sometimes it's inferred. You can only infer it. And that's where comparing the case to what an academic or a practitioner in an article or a textbook has said is really important. Because if someone said, the judges here, what they were saying they were doing wasn't what they were actually doing. Well, how would you know unless you go and read the case? And obviously you're looking at, well, out of everything that led them to this conclusion, well, what were the most important factors? And then finally, what are the implications for this case, for the essay you're writing or the dissertation that you're writing? And I think taking your notes and bearing in mind these factors will give you quite a structured approach to appraising the case. So then you can take your 3-page roadmap and then begin to answer these questions, or whatever question you're looking at. So you've done all that. You've taken a summary of notes. What do you do? Well, I think you should go over the key passages. You should identify what the key passages are and go over them, if there are any. If there are particular key passages, it might just be that the whole thing's really, really interrelated and that it's only like 1 or 2 paragraphs where they give the final decision, but the whole reasoning's really important. Fair enough. You can compare what's in the case to what's in the textbook or the commentary. Good idea is to phone a friend to both agree to read a case and to compare notes. And that's a very useful thing to do. And then you will inevitably have a list of things you didn't get you didn't understand, you didn't follow from the case. Now, I really want to stress this point, because reading a case is like any kind of technique, anything you do, you'll get better at it. There are times when, again, the judges are, they're human. They may explain things in not a particular way, in not a particularly good way. You may have your own blind spots. We all have our blind spots. So don't get put off reading cases because there are bits of it you didn't understand. Be proactive. Don't be negative. Take what you can from the case, and the things that you don't get, like I didn't understand this paragraph or that paragraph or how this meshed with that, whatever the question is, write it down, discuss it with your fellow students, and raise it in class with your lecturer. So quite a important practical step. If you've already been doing a degree for a while, this was obviously not news to you, but you find the cases either at the websites of the particular courts, or they've been collated in a number of different legal search databases. The most popular is one called Westlaw. And if you know the name of the case and you're just getting it from a seminar handout, obviously it's really easy. Just type in the name of the case and out it pops. For research, though, for research purposes, a very good thing to do is to go to Westlaw, to go to the cases bit, and then use a keyword, and it'll find all the cases that relate to that particular keyword. If you're looking for cases that relate to particular legislation, that search engine also allows you to type in the provision and name of the legislation, and it'll find, again, cases that interpret that provision. If you want to find commentary on a case, well, again, a textbook may refer you to commentary on a particular case. Another textbook may have it in the footnotes, and they may say, look at this analysis by so and so on this particular case. But another way of doing it is finding the case itself on Westlaw, and once you've found it, on the left side of the toolbar, you'll see a link called commentary, and if you click on that, it'll give you the option of looking at journal articles that mention that particular case. And from the length of those journal articles and the title, you can figure out if there are any case notes on it, and if there are any more in-depth articles that kind of tease out some of the implications of the case. Finally, I think the really important point to take out from this is, as with everything, reading cases is like, weightlifting. The more you do, the better you'll get with it. There will be things that you don't understand in cases, just as there will be things you don't understand in textbooks or in articles. That shouldn't stop you from reading them. Think of the long term. So think of, if I read 1 or 2 cases a week, by the end of an academic year, I will have read a lot of cases. I will have read 40 odd cases. And compare that to what you're doing now. So if you're reading no cases, by the end of the academic year of reading no cases, you will have still read 0 cases. Whereas someone who at least tries to read a case a week will have read 22 cases. So they'll have 22 times the experience that you do. And they'll potentially have a much more in-depth knowledge, even if they're not fully understanding everything in a case. You're not expected to. But it's important to do that because it really does help your critical analysis skills. And any gain you make from reading cases is going to be time really well spent. So please don't be afraid of them. Keep practicing, and I hope you get a lot out of it.